The learning outcome of this video is for you to be able to describe the process to apply for a grant of probate. You should note that different countries have different laws governing management and distribution of estates. In Singapore, a grant of representation is required to enable the personal representative to deal with the deceased person's estate. For example, to transfer or sell property or to close bank accounts. There are two main types of grant of representation: a grant of probate and a grant of letters of administration. The essential differences between probate and letters of administration are: first, probate is applied when the deceased left a valid will, and letters of administration is applied if the deceased did not leave a valid will. Secondly, probate will be applied by the executor named in the will, and letters of administration is applied by the beneficiaries of the estate, who may include the spouse, children, parents, siblings or other next of kin. Grant of representation is an important document. The document is obtained from the court to prove the legal authority of the person entrusted to deal with a deceased person's estate. This person is known as the personal representative. In this video, we will focus on the process for cases where the deceased left a valid will, and you are the executor named in it. Firstly, you must apply for probate within 6 months from the deceased's date of death. However, if you are applying for probate after 6 months, you must provide the reason for the late application. The application can be made through e-litigation if you are represented by a law firm, and through LawNet and Crimson Logic Service Bureau if you represent yourself. The application must be made to the family courts for estates worth up to 5 million Singapore dollars and to the family division of the High Court for estates worth above 5 million Singapore dollars. There are 4 essential documents must be submitted when the application is made. These include the schedule of assets, the original will of the deceased, a summary report of the court's record of probate cases and caveats, and renunciation of other executors. There are also other supporting documents, and some of them must be certified before the lawyer, which are the deceased will, the deceased death certificate, and the death certificates of other executors if applicable. You will need to submit all the following documents within 14 days after you apply for probate. The first one is a supporting affidavit. You confirm on oath that the information and documents you have submitted to the court are accurate. Second, an administration oath. You confirm on oath that you will faithfully administer and account for the estate. To recap, these are the 2 main types of grant of representation. I think I should change my will. My offspring should get everything. This is much better. Everybody got what they deserve.